Hello, and welcome to our Value Beyond Insurance webinar series. I am Jen Beach and wanted to get us started today before we welcome our speakers. I wanted to just start by reminding everybody that your cameras and microphones have been disabled for the webinar. So if it's not working, that's why you're not having any technical difficulties. Those are disabled by design. Secondly, our webinar will be recorded today and will be emailed out following the conclusion of our webinar. So if you missed anything, don't worry, you will get a copy of this recording sent to your email. Lastly, I would like to encourage everybody, there's going to be a lot of content covered today. This is a really hot topic with employment law, and we're anticipating a lot of questions. So we are asking that you utilize the Q&A feature. Depending on which version of Teams you're on, it's either going to be up at the top of your screen or possibly down at the bottom if you're on a mobile device. Just click that Q&A box, type your questions in there as they come up. We will monitor those throughout the webinar, and we'll save some time at the end to make sure that those questions get answered. So without further ado, I am going to ask Gerald McMichael to join us to get things started. Take it away, Gerald.
Yeah, good afternoon, folks. For those of you on this call I haven't had the pleasure of meeting yet, allow me to introduce myself. My name is Gerald McMichael, president of the McMichael Insurance Agency. We've been around for nearly 50 years, formed as a family-owned agency, still have that hometown feel, but we have nationwide reach, serving clients and personal insurance clients from coast to coast. We are very much viewed from inside the insurance industry as a thought leader and an expert in the area of coverage application and interpretation, and as a provider of insurance solutions and superior services to the business community. I want to welcome you to our Value Beyond Insurance webinar series. Our topic today sounds simple, but don't let that fool you. We simply titled it Developments in Employment Law. Before I say more, let me first introduce our sponsors. This webinar is sponsored by McMichael Insurance Agency in conjunction with Peer Executive Groups and GRSM. GRSM is a nationwide law firm of which Greg is a partner. He is our presenter today. Greg, I'm going to leave it to you to flesh out the acronyms GRSM because I don't know how to say some of the names there. But I'm sure he can fill you in on any details you want to know. Peer Executive Groups is a best practices group that helps business owners drive revenue growth through the sharing of cutting-edge ideas from among industry peers in both the equipment dealer space, rental industry, and also the insurance industry. Welcome, Peer Executive members. I owe it to you also to tell you a little bit about our presenter, Greg Meehan, and our relationship with him. Greg and his firm GRSM are in a class of their own. Just to mention a few of Greg's achievements, he's achieved super lawyer status, received the Lawyer of Distinction status, along with being designated as a Michigan top lawyer. Yes, he did, you heard me right, attend Michigan State University. Ohio State fans, don't hang up yet though, because he did receive his Juris Doctorate degree from Ohio from the University of Toledo. Greg, I'm glad to see you throw our Ohio State fans a bone. Here's the best part though. Listen up to this. This is important. As an added benefit to the clients of McMichael Insurance, we do make the services of Attorney Meehan available to our clients at no cost. You heard me right. The cost of his services have been totally underwritten and are available to clients of McMichael Insurance at no cost. Let me just tell you a couple things Greg has done for our clients at no cost to the client. Creating new employee handbooks from scratch, consulting on rewriting an employee handbook to make sure nothing is missed, consulted on termination procedures for employees who have gone off the rail, put together performance improvement plans, discussed recreational drug use with a Michigan client of ours. Ohio now has recreational drug use available, and something you need to learn to navigate. What is actionable evidence to be able to run a drug test on a specific employee? So those are just a few of the topics that we have tasked him with. Our topic at hand today, though, is, as you can imagine, in the era of a Trump White House, there's a lot of movement in executive orders, wholesale terminations of several federal agencies. There's a lot of shifting in the area of employment laws of late. So let me just say, buckle up. This presentation is going to hit light speed and very fast. So that's about it. I've topped out on my pay grade. I'm going to turn it over to Greg Meehan, attorney at law. Greg, floor is all yours, buddy.
Good afternoon, everyone, and welcome. During the presentation, I really would enjoy if you get a question you want to have answered while we're talking, just put it into the communication sidebar, and Gerald or I will catch it, and we'll try to make that answer immediately as part of the normal flow and stream of this presentation. Number two, this PowerPoint, all you need to do is ask for it, and we can make sure that you get a copy of it. And third, before we begin, there will be some references to certain guidelines, specifically when we're talking about remote work, that to the extent that you want them, we can put them in the mail to you, email, and allow you to look at them. They're very informative, very instructive, and very difficult to understand without having a full review of them in complexity with the others. So if we could go to the first slide for a moment. I kind of named this my, what I would call my development in the employment law, and I call it the Special Force Edition. This is in recognition of Marcus Luttrell. Some of you may know who he is. He was one of the guys that survived in the lone Red Wings mess up lone survivor. Buckle Up Buttercup was his special word that he used to use for SEAL Team 10. And I'd met him as part of the Afghanistan engagement that I was in with the Navy through this process. So I thought we'd make this a special presentation involving him and his ability to take all of the chaos of life and succeed, because that's what's happening right now. Next slide, please. These are the 10 topics that we're going to go over real quick, just to take a view of them. Some of them will be very fast. Some other ones will require a little bit more of an explanation, but by the end of this presentation, I hope to be at the end. Most of these have been the direct result of changes in the Biden administration, the Trump administration, and the U.S. Supreme Court deciding just to go crazy since January of last year, and the impact is only now being felt. First slide after this, please. So as many of you know, Trump has had a lot of fun once he took office. Whether you like him or not, you got to give him credit. He has issued 34 White House executive orders rescinding orders that were initially proposed by both Biden and before Biden, Obama, and a few even before that. Many of the ones that he rescinded deal with these preferential treatment, race, gender, sexual identity, sexual orientation, and immigration law. Next one, please. And he has notably issued two, if not three, White House executive orders that are shaking the ground today and are filling the pages and the televisions with newscasters having things to talk about. The first thing that he did was to remove 3 of the 5 National Labor Relations Board members, who were all Democrats, from the NLRB. What that essentially has done is made the NLRB unable to navigate, hold hearings, and continue the engagement of their agency mission and vision statement, because with only 2 members of the board, you don't have a majority, and they're not able to pursue those issues that the NLRB is about. And by the way, for those of you that think that the National Labor Relations Act deals only with union organizations, it does not. It specifically applies to unions and union employees and companies, but it also applies to all exempt employees, non-exempt employees who are engaging in what is called Section 7 and 8 rights. And those Section and 7, 8 rights are ones where the employee engages in communication about the terms and conditions of their employment. We'll have a little bit more of a discussion about what that means. The second thing that we are all aware of is that he has recently removed through a White House executive order all DEI initiatives. And what that means is he has required removal of programs, policies, procedures, management processes where DEI and gender identity have been the primary focus of activity. In other words, it's still illegal, thank God, to discriminate against somebody because of their gender identity, their sex, their national origin, or everything else. But what the DEI White House executive order does, it says, while it is illegal to discriminate against them for this, what it is not permitted to do is to create programs that promote or give a preferential treatment for those categories of DEI and identity. In addition to that, some of you may be aware that he recently promulgated also all federal government agencies and those receiving federal funds, which includes high schools and colleges, from allowing transsexual or transgender, however you use that terminology, from competing in sports that is not aligned with their biology. So in other words, high schools and colleges have had to remove males who now claim to be transgendered females from competing in male sports. And one more thing, back to the DEI initiatives and everything else. While this focuses on removing initiatives, patterns, and programs and everything from entities like EEOC, DOL, NLRB, Immigration, the IRS, all of the governmental agencies that now have to stop with these programs, that also applies to all of those entities, private companies that are recipients of federal contracts or federal grants or federal engagements. So it's been a big change. When you consider the fact that now we are with federal government saying DEI, sexual identity, and gender identity are no longer those items that can be promoted or given preferential treatment, but you compare that to most of the states in the United States that have actual DEI and preferential treatment for gender identity in their state law. So as employers, we're in this difficult situation, not unlike what we were in during the COVID times. Some of you may remember there were laws with regard to schools and Head Start programs and employers that said if your people did not get vaccinated, you either needed to accommodate them if you could or fire them. And then, of course, when you fired them for not being vaccinated, the government took off running and left the private employers to be sued by the state government and the state law for violating the state law. You complied with Fed, but you're not complying with state. So we're in this quagmire that is just difficult for anyone to migrate around as you comply with the federal law, because if you don't, your money gets frozen. And if you do, you are opening yourself up to being in violation of state law in that regard. So that's what the White House executive orders have done. And that's why we're getting all of the noise in the newspapers, the television shows, and the news reports. Number 3, please. Now, Supreme Court ruling since January. It's been crazy out there. The first one, not so crazy. We had the Pregnancy Workers Fairness Act went into effect last year in June. And what that is just another federal law that's imposed upon companies that are designed to protect pregnant women. Now, thank God that they do that. This makes the third law that exists for pregnancy-related incidents. The first law is Title VII, which makes it illegal to refuse to hire or promote a person who is pregnant. Then we have the Americans with Disability Act, which makes it illegal to not try to accommodate a pregnant worker from being able to continue to work. And the ADA and Title VII provide substantial monetary damages against an employer and against managers and supervisors who are deemed employers under the law for violating the law. And then we have the Pregnant Worker Fairness Act, which basically has no ability in terms of hiring and firing. It deals specifically with clearing up the idea that employers must make every opportunity it can in a possible manner to try to accommodate the pregnant worker to continue on working throughout the pregnancy to the extent that they wish to do so. The second change, and this one, in my view, is somewhat earth-shaking, and that is there's a new standard for affecting the terms and conditions of employment with regard to transfer. In the past, it used to be that if you as an employer decided you were going to transfer an employee to another position, either because they weren't doing well, either because of discipline issues or because of need, you could just do that, and the business judgment rule would allow you to take that and go forward with it. Now, today, the court looks at whether or not the activity is retaliatory and whether the activity is designed to discriminate. This case, Murray, and the case McDowell, all dealt with certain employees who were demoted for other people where the disciplinary action wasn't established and where the wrongdoing could not be proven. And the court, in fact, imposed a high standard of proof on behalf of the employer before you do that. And along this same line, and it's not on your screen, the U.S. Supreme Court decided in June of last year that forget the fact that 45 years ago, we told every employer, if a person has a disability, you only need to accommodate it if it's reasonable. And reasonable was defined as whether or not what you had to do didn't require more than a de minimis cost. In other words, if the accommodation for an employee under the ADA cost more than $100, more than $500, more than any kind of what you would be deemed to be de minimis, then that was too much, that was unreasonable, and the employer was not compelled to be able to fulfill that responsibility. And that's been the law for 45 years. And the U.S. Supreme Court in June decided, you know what? You all had misinterpreted what we said, and we're not changing the law. We're just telling you that you've misinterpreted. The law now requires reasonableness to be viewed from the standpoint of a substantial financial hardship or substantial financial cost in trying to accommodate that person. Then and only then can you claim hardship and deny the accommodation. And I just want you all to sit back and pause for a moment when we look at the word substantial, because I know that each one of you listening to me today would give me a different definition of what substantial means. And it also would be different in the context of each and every case that would be confronted with. The same thing with regard to financial hardship. What is a financial hardship? What is something that can be overcome? One would think that the EEOC's belief of financial hardship would be when you have to file bankruptcy, you've established the financial hardship. So don't worry about accommodating the employee, but that in that case, you're too far gone to even be able to care whether you need to accommodate. This is a difficult standard. It puts a difficult responsibility upon employers, managers, and even fellow employees who are now compelled to do more for the same amount of pay and the same amount of hours as they're trying to accommodate all of these different things within the workplace. And we can no longer just simply say, we would like to accommodate, but it just doesn't work. It's frustrating. The customers are angry. This is that. This is that. You have to actually come forward with proof of a substantial financial hardship. And then one more that's not in this realm is what I call the new law, the new wave that's coming this way. And it started before the Trump administration, but it is now accelerating. And that is the battle between the rights of transgender or sexual identity, and which is protected by Title VII. Remember, the DEI and the White House executive orders only says you can't promote programs that give preference to those, but it can't. The White House order can't take away the protections in Title VII of that right. And so now what we have is the religious freedom right and the transgender right battling. And we recently had a case where a person came into the workplace, was a male by birth, wanted to be called Daniela because she were transgendering over, and required that that person be called Daniela by everyone in the workplace. And technically speaking, 5 years ago, the EEOC said, if you don't do that, we're suing you. Sorry about the lights going off here. I have a weird system in my office that shuts the lights off if I'm not moving a lot. So we'll just stay in the kind of dark here. It's kind of mysterious. But anyway, if you didn't force your employees to recognize the transgender status and name, the company would be sued for millions of dollars and have to change the process. Well, this one guy said, I'm not doing it. It's against my religious belief to call a biological male a female name. And the company, following the EEOC law, fired him. And lo and behold, our federal court system said, whoa, wait a minute. He had a religious right to engage in activity that was within his sincerely held religious beliefs. And he proved that he had a sincerely held religious belief that calling a male a female name in the workplace was violative of his beliefs. And therefore, employer, what you should have done is brought them two together in a room. Love to have been there when that happened, and have them try to negotiate out how the protection of the religious freedom in view of the one individual, desire of the transgender individual called a certain name, would occur. And of course, that is not only almost impossible to work itself out, but it's also somewhat demeaning and difficult to do. And the court found that because the employer did not do that, then the employer violated the religious freedom rights of that individual and awarded him substantial dollars. It was well into the million. And ultimately, he had to be brought back to work. And ultimately, as my understanding has now occurred, they had that meeting. It didn't work out well, so the employer just fired both of them. And we'll see if there's going to be more lawsuits happening that way. And the last little point that's on this screen is, does the transportation worker, and this is a specific sect of workers in America, and their ability to be exempt under the Arbitration Act. And this just basically means, does a transportation worker have to work for a company in the transportation industry to be exempt? This doesn't apply to most of you in this conversation, but just be mindful of the fact that the Federal Arbitration Act does apply in many aspects of federal businesses today, and in state businesses if you've included it in your employment agreements. And this just gives that one exemption out of it. Next one, please. Federal Court of Appeals evidence rulings. I thought this would be interesting to you. That came out of the Fifth Circuit in Texas. For those of you that are well aware, Texas is the court that most of us defense lawyers go to when we want to change the federal law, because in our understanding and view, it's the most conservative court. It's the best court to engage when we're looking at overstepping by the federal government. Most of you may know that we ended up winning the exempt salary increase that was supposed to go in effect in January by finding that that law was unconstitutional. And for those of you, I hope I don't cause anyone consternation, we also won having the courts deem the Corporate Transparency Act and providing the BOI information to be illegal or void. And that has been upheld. So those of you that have not submitted your BOI information to the federal government, thank God you haven't done that, because you've got a good idea what's happening right now with that information, where it's getting found, what's happening with it. And that's one of the reasons why the government didn't need all of your personal business and home information. For those of you that had provided that information, I want you to know we are working to try to get it expunged. But right now, compliance with the Corporate Transparency Act and the BOI is voluntary, meaning you can do it if you want. I'm just suggesting to you, you never want your personal information out there. All right, now back into these evidentiary issues that have been plaguing lawyers for years that I think would be interesting to you at least. We used to have cases where we take the deposition of someone and they'd say why. And then when we file a motion to dismiss the case, they file an affidavit that contradicted what their sworn statement in the deposition was. And the courts would just go in a fluster, not knowing what to do. And finally, it took the Fifth Circuit to say, no, you can't contradict your prior sworn statement with an affidavit because it looks like you're just simply trying to provide evidence to sustain your case. And the next thing that's important is your previous statements to administrative agencies. Many of you worry about when you file for response to unemployment, whether or not what you say in that unemployment filing to defeat an opportunity for a person to get benefits, will that be used against you? Can that be used against you? And the answer is no, it can't. Unless you were found to have lied. And of course, anytime you lie, any document can be done. But what they can't do is use administrative findings against you in another case or another court to prove that you were wrong there and therefore you're wrong here. So bear that in mind so that as you work for specifically unemployment responses, when people are applying for it and you don't believe that they're entitled, you need to be specific. And you can do so with a carefree environment that what you say, despite it being honest and truthful, will not come back and haunt you in any way. All right. Number 5. The NLRA expansion. This is a crazy part of this whole area that most of us are not, at least not having experience with, because as a non-union companies, it's very rare to see the NLRA or the NLRB in the workplace because there's no union to be involved. But right now it's happening over and over again where handbooks are being attacked for violating Section 7 and Section 8 of an employee's rights. In fact, Wendy's recently got destroyed for their handbook because they had policies that say an employee cannot, I'm quoting here, an employee cannot denigrate its customers, clients, or vendors, or an employee cannot be insubordinate. And the NLRB found those prohibitions in a handbook to be illegal disciplinary standards because they were ambiguous, arguing that what does insubordination mean? How can an employee gauge their activity? And I guess the best activity that I can try to tell you is I had a case, some of you may have heard this before, but I had a case where a probate judge was embarrassed on social media because one of his staff person talked about the, let's say, size of his genitalia as a way of explaining why he follows her around to find mistakes on her behalf to make him feel better about himself. And when the judge heard that, the judge got so upset, he wanted to fire that person because that person had made something that was not only insubordinate, but offensive and illegal. And the answer to the question was, could that judge fire that person, was no, because the employee has the right. These are non-exempt employees, not exempt salaried people. These are hourly employees, have protections of Section 7 and 8 under the law to talk about the terms and conditions of their employment, as long as they are talking about their job with another employee and the impact that their job and other people are having on them. Now, we ultimately terminated that individual for reasons that we end up catching them in other statements that were actual threats. But there is real concern with the NLRA coming into the workplace today, both in a union and non-union setting. And there are two other aspects that have recently come out with AI becoming part of the world. The NLRA is starting to look at company monitoring of employees' computers, PDAs, and other in-office engagements, not just limited to video cameras, as a way of violating the employees' Section 7 and 8 rights. The goal here is not to make you lawyers about this issue, but at least to recognize that there is this push by the NLRA to jump in and do this. Now, do I think it's going to continue? Well, as we talked about earlier, Trump administration, the first thing they did is cut off at the knees the entire NLRB by removing 3 of its members where it can't even act. Do I think there's going to be substantial pushback on these processes and procedures? Yes. The question becomes right now is we're in the middle, and I just want you to know what's the middle ground. I think at some point in time, the administration is going to have the rules back the way they were, where companies have the ability to engage in any manner that is appropriate and acceptable for monitoring their computer systems, their PDAs, their offices, to ensure the safety of other employees and wrongdoing by other employees. The last part about my NLRA expansion is I just thought for some of you it would be interesting to understand. Many times people ask me, Greg, what does it mean of activity that can happen in the workplace that could be union oriented? And what I put in red are things which are typically deemed as concerted activity for union organization. Employers should know a little bit about that and should be mindful of the fact of you can't get into the way of those types of things. And so, for instance, an employee discussing concerning low wages with coworkers, circulating a petition asking for improved benefits, those are all Section 7 and 8 protected benefits, protected rights to be able to do. And today's employer has to be ready to engage that person in a way that's non-retaliatory. All right, next one, please. Oh, and by the way, all of these things we're talking about when we talk about employers, we're talking about the impact it also has on employees that are managers and supervisors, because under the law, managers and supervisors are deemed to be employers also. So you are subject to being sued just like the company, because you are the representative of the company by being a manager or supervisor. Number 6, remote work. Now, this is where I talked earlier that you see on the right all of these parenthetical with these issued this day, 2/3/23, issued effective 6/18/24. I have the actual articles like these that kind of explain in much more detail of what each of these guidelines provide. But it is important to note that while we have a lot of pushback in the private market, Elon Musk being one of them that you're all aware of, requiring all of his people to come back to work, and faced quite a few lawsuits, but was successful. And we've got the Trump administration's White House executive order cutting off remote work in the federal level. We're going to continue to see this push-pull of remote work being taken away and bringing everyone back into the marketplace, and employees pushing hard not to have to come back to work. There's a lot of economic issues that go on with that. There's a lot of performance problems that have occurred. There's a lot of people that do really well remote, but there's a lot of people that are not doing as well. But what I wanted to let you know is the EEOC has listed their own guidance as it relates to telework, and have stated that under certain circumstances, remote work is an accommodation for someone with a disability, as long as that accommodation is reasonable. Now, when I say that, that means an accommodation from a short term, midterm, and potentially could even be an accommodation of a permanent basis. And that's the biggest, hardest, most difficult part that we're dealing with today. I probably have 20, if not 30 cases where the employer is striving hard to keep the person at work and accommodating in every way they can in the workplace, but the employee and the doctors are writing any note you want them to write to say that person should be able to work from home full time. And then there's the battle and the potential lawsuit. Pregnant Workers Fairness Act requires, of course, the consideration of working from home as an accommodation. And then the harassment in the workplace also allows for accommodating a person who feels that they're being harassed to work on a temporary or a mid-level type of basis. Regardless of what you do, if you're going to engage in remote work, or if you think it could come about as a result of an accommodation, you've got to have a strong policy so that you're able to pull it back when you need to. The second thing you need to know is that when people work from home under state law, their home is a new work site for each and every employer. Their home is subject to a workers' comp case if the employee working at home trips over certain things in the workspace that they're working for. Their home is also the place where security of lines and stealing of information from the company can occur. So I recommend that every employer have a remote policy, even if you don't offer it. But if you do, it's a remote policy that gives you the ability to cut it off. It gives you the ability to inspect the home office. It gives you the ability to ensure certain safety nets and safeguards to ensure that you're going to reduce workers' comp and other types of issues. And more importantly, the biggest issue, the DOL, as we track down to there, is tracking hours. We are seeing case after case of overtime being filed against employers because the remote worker worked beyond the hours that the employer permitted them to work as an hourly employee, and yet still worked and then demanded pay. And unfortunately, the employer didn't understand that their obligation is when that happens, you have to pay them. But then you can discipline up to including termination. And many employers are of the view that our handbook says you can't work, so we don't have to pay. And the Department of Labor is no, if you're getting value, then you have to pay. Now, the question becomes, how do you monitor overtime work at home? How do you monitor someone not getting on their cell phone and checking emails? How do you monitor not text messaging non-exempt employees each other about work-related matters? Those are the things that create overtime problems, and they're going to continue to create. And the need for strong policy about remote work and what you can and cannot do, and enforcement is what's most important. And then finally, the other guidance, the presidential memo on remote work, which is no, and the NLRB memo that we talked about, which is and you got to give it consideration for all the reasons we've talked about. So don't miss out on the idea that you don't have to allow remote work. There's no law that says you do, except as it relates to accommodations under the ADA or under the Pregnant Workers Disability and Fairness Act or under Title VII for harassment. But as you start saying or, the exceptions start to outnumber the no. And that way, then the only way to really get the control you need is to have a policy that says, if we ever do it, these are the things that we're going to do. We let your insurance agent know you're doing remote work so that you can make sure you're insured for workers' comp incidents at the home. And we inspect the home, we inspect what's going on, and we protect our assets and our information. All right, next one, please. Sexual harassment, this is something that's been since time immemorial. We can go back to the Roman times and talk about it. There are just some things I wanted everyone to know. Sexual harassment may not always result in sexual assault, but all sexual assault would be sexual harassment. Please understand, everyone, unwelcome touching, unwelcome comments is element number one for sexual harassment. And I can't define it for you. No one can define what unwelcome is. It starts in the eye of the person who's on the receiving end of the comment or the touching. And therefore, because I can't define it for you, you need to understand that the only way I can guarantee you don't get yourself into one of these issues is you just don't engage in communication that is unrelated to the job that you're doing. And you don't neck rub, you don't rub someone's hands, you don't rub up against them, you don't touch their shoulder as you walk by, you don't give hugs. I get it. It seems weird to say that, but you don't do that. And I had a guy one time tell me, you got to be kidding me, Greg. I mean, I can't comment about a woman's glasses or a woman's purse or the way she's dressed. And I kept on telling him, and I could see he wasn't getting it. And I finally said to him, I said, Jim, let me ask you a question. He said, what's that? I said, have you ever walked up to another man and said, damn, Steve, you look good in those jeans? And he said, no. I said, well, there's a reason. It's called biology for part one. But number two is your initial comment had nothing to do with the woman and her work and her status as a human. It had to do with your biological response to it. You don't do it to men, then you can't be doing it to women, because it shows the distinction between why what is and what is not welcome. And by the way, the women that are listening to this, you guys are being attacked. In fact, I think there's some statistics out there now that we're saying women are being sued 2 to 1 over men on sexual harassment. Why? Because women, you will comment to men about their looks, and you will also comment to women. And so you're on both sides of this conundrum in this regard. Now, I know there are exceptions. I'm not talking about gay and lesbian kind of relationships and that. I'm just talking from a general perspective that I can't define unwelcome for you, so you need to stay away from the engagement of it. And understanding why it happens is the first step. And number two, being apologetic when it happens is the second step. The other number two, the other term of harassment and hostile work environment, it has to be severe. That means usually a touching, or pervasive. That means a number of times over a week, over a month, that there's a joke or that there's a comment or that there's looking at that. Victims must subjectively perceive the environment to be abusive, and the conduct must alter the conditions of the employee's work. Y'all been in high school once, right? You all remember that if you were part of the band and you were walking by the jocks, or you were walking by the drug users or the smokers or whatever, if you weren't part of the group you were walking by, you got razzed. And if you didn't get razzed, you didn't go to my high school. So that's what it means when it says the environment is abusive or conduct, in the sense that it causes them to be in a different manner. And employers get sued because managers get sued because managers don't manage the employees to stop them from the activity, or the managers engage in the activity themselves. And there's a concept called vicarious liability that makes the employer responsible. So this law has continued to evolve, and even as of yesterday, we're getting new different cases about how sexual assault is defined, whether it's harassment, sexual assault, or even rape. Next slide, please. Religious accommodation in the employment. We've already spoken about this. in the sense of the undue hardship. Like in any accommodation, the hardship now is substantial financial cost. We talked about the battle between transgender and religious rights. And the last thing that I wanted to talk with you about is make sure that your handbook policy provides that although you've got a dress code, there must be a provision in there that talks about if someone comes in who's employed with you or a third party or a vendor and who has a particular dress need or code based upon their religious beliefs, you have to accommodate that, provided it's safe to do so and will not ordinarily cause disruption or harm to other people. Let's make sure that we are looking at our handbook policies so that we have that terminology there. Next one, please. Investigations. I wanted to have this. Make sure you ask for the PowerPoint, but when you are asked to do an investigation, whether it's someone complaining that this person harassed me or someone did this, or there's an accident investigation, someone damaged this or didn't turn this on, the takeaways are 5. You got to act promptly. I like to say the faster you act within 3 days of the event, that's the best. Anything beyond 3 days is too slow. Number 2, be consistent in the way you do all of your investigations, meaning ask questions to the harasser, ask questions to the victim, ask questions to the witnesses, complete it. Number 3, do not divert from your normal protocol. Develop whatever protocol you think works, but don't divert at all for it, because any diversion is going to look like it is on the benefit or for the benefit of someone else. You can't investigate what you don't know. And so therefore you should have a policy in your handbook that mandates that employees of your company are required to participate in investigations when something is being investigated on. They can't say, I don't want to get involved. I'm not going to say anything. I'm not doing this. If they take that position, they should be disciplined. And if they continue to take that position, then you should terminate them, or at least consider that. I know as tough as that sounds, but remember, terminating somebody because they refuse to engage in helping you effectuate the protection of someone's civil rights is not a protected activity. And then when we look at the last one, you should have an escalation policy. And that is basically if the person who's doing the harassing is the person you're supposed to be responding to and informing that you're being harassed, you got to have a policy that there's another person that you could go to. And then after that, some companies even use hotlines or boxes that only certain individuals can go. But you need to have that kind of policy. If you have this, your investigations will be granted what is called the business judgment rule, and they will prevail. You don't have to be right on your investigation. You just have to act in good faith. And if you act in good faith and follow the consistent process, whatever the outcome of that investigation would be is what's going to be sustained. Because you got to remember, many times these are he said, she said. Next one, please. All right, this is the end kind of my presentation, but I want to just raise this to you. Human trafficking is still a big thing. I suspect it's going to be even bigger as we start to fight the cartels. One of the big things that was happening 20 years ago is the cartels would come into the United States and try to traffic out women and boys across the world. And then, of course, they got smart and started just recruiting people within the United States who are citizens to do human trafficking. And then they wouldn't risk themselves being in jail. We're also seeing now lawsuits where companies are being sued for hiring people who have been human trafficked and didn't take action. Now, granted, you don't have to ask questions to every male or female that you employ, are you being or subject to being human trafficked? But what you do have to do is be aware of whether or not that's a possibility. Then you can take it to the next stage. So in the red, I put whoever knowingly provides or obtains the labor or service of a person by one of the following means: force, threat, restraints, serious harm or threats, abuse or threats, or any scheme, plan, or pattern intended to cause the person to believe that the person didn't perform, that person would suffer serious harm. Now, those are usually directed at the person that's making that other individual apply for a job and work, but they are now applying it by way of third-party argument that you're a third-party beneficiary of a human trafficker, so you should also pay. And although there's been no verdicts, there are a number of lawsuits against companies today where the average request for damages is in the tens of millions of dollars. And I don't believe, I've done a couple surveys to certain carriers, that there is any insurance coverage at this point in time that protect employers who happen to hire someone who's being human trafficked by either one of their own employees or not by one of their own employees, some third party, but they have an inkling and know that that person is being trafficked. So this would be something you may want to talk with your insurance agent at that point in time to see if there's any thoughts or concepts. With that said, I have completed what I wanted to do. I would plead with you all to get a copy of the PowerPoint. And like I said on the remote, there's a bunch of articles that are referenced there if you would like them. The guidelines in them are fantastic. They answer many of the questions you may have. And of course, I'm available if you need help with your handbook. It's free. It's part of the program. If you need a remote policy or anything else that you need. And I thank you for allowing me to drone on a little bit with you guys. God bless you.
All right. So I hope you've found this episode of Value Beyond Insurance helpful to you and your business. I'm going to let Jen add a couple remarks and then I'll close it out. Go ahead, Jen.
Yeah, I just wanted to say thank you all for coming. Like I said, we will be sending out the recording after this video. You'll get a second email with a copy of the PowerPoint presentation notes so that you can reference back to those, as Greg had mentioned. If you have any questions, we still have about 7 minutes left, 6-7 minutes left. If you want to pop any questions into the Q&A, we can try to answer those. Or if we run out of time to answer those, I'm sure that we could email those to Greg and he could give us some answers that we could email out to everybody as well. But that's all that I have. I'm going to turn it back over to Gerald to close us out unless anyone has any questions. I don't see anything popping into the Q&A at this time.
I can tell you there is a whole lot of implications coming out of everything Greg just talked about. So if you don't have questions now, I'm sure you will at some point. So we'll make his information available. I just want to remind you that when you insure with McMichael Insurance, your business can literally save thousands of dollars in legal fees by taking advantage of the services that Greg provides. We've totally underwritten the cost for his legal services. You can reach Greg, and I'm sure that the information will be sent out as the slide deck of the PowerPoint goes out this afternoon. The next time you think of insurance, think McMichael Insurance. You can reach my office by calling us at 330-626-4972 or by going to mcmichaelinsurance.com and completing a contact form. I might add that as organizer of this webinar, we do have ongoing efforts to bring these to you on a regular basis, so keep your eyes on your email inbox. Our next event is in April. The date is to be announced, but keep your eyes peeled. We'll get that invitation out to you as soon as we've got things finalized. If you're on this call because of a sponsor who invited you to join this webinar, please say thank you to that sponsor. That's all I have. I wish you all have a great rest of the day and God bless you. Thank you. Bye now.